Okay, so we already talked about the concept of the law being a fabric, and now we're going to talk about sources of the law. So essentially, where are the different places, you could almost think of it as the threads of the fabric. Where are the different places that the law actually comes from? And the book actually identifies 7 of these. The first of those is called common law. And common law essentially comes from the courts. And common law is a system that traces its way all the way back to England in the 12th century. And the idea there was that common law is also a lot of times called discovered law. And the reason is the idea that when there is a problem that emerges, the court's job is to basically find a proper solution to that problem that has already been decided. In other words, if there's a problem that comes up, there is a pretty good chance that a problem like that has happened in the past. And so, what happened in the past when there was such a dispute? Uh, you know, Similar to the one we're dealing with now. So this brings up the idea of stare decisis, which essentially means let the decision stand. And this is the idea that once again, when a issue comes up, a dispute between two people, for example, chances are there's been a similar dispute in the past, and so we want to look at what did they decide in the past. And generally speaking, unless there's a reason to, we should essentially decide the same way as they decided in the past. Hence, let the decision stand. This is also known as following precedent. So essentially, a precedent is the idea that we did something this way before, and so we should do it now as well. There are exceptions to following precedent, which we'll address in a separate presentation. But generally speaking, when we're talking about common law, this is what we're doing. We're basically looking back to cases that have already been decided and essentially deciding, how do we resolve this case based on what's been decided in the past. Next, we have law of equity. And law of equity also comes from courts, but law of equity is used in situations where the common law doesn't really provide any guidance. For example, in law of equity situations, we never have a jury. Instead, essentially, we just rely on a judge to make what is often called a decree, which is DECREE, and the decree is supposed to be based on equity or fairness. So some examples of equity decrees would be an injunction or a restraining order. So if you have somebody who's a stalker who's following you around, you can basically go to a court and essentially provide the evidence of what's happening, and if the judge believes that it's proper, he might provide you with a restraining order that essentially says that this person's not allowed to come near you, or this person's not allowed to call you or text you, or do those sorts of things. Law of equity also comes into play, for example, in child custody cases as well. So law of equity also comes from courts, but it generally deals with really, really, really specific issues. The kind of issues that, essentially every single one of them is a little bit different. And then we have constitutional law. And I'm sure you're all familiar with the idea of the United States Constitution. There are also state constitutions, for example. There are city charters. There's even a Bowling Green State University charter. And what a charter or a constitution does is more or less outlines how a government or organization will work. So, for example, in the United States Constitution, it tells how laws will be passed. It basically sets up the three branches of government, the executive, the legislative, and the judicial, and provides an outline of how those will be structured. And, it more or less just provides this idea of an overview of how the country in this situation, in this particular case, I should say, how the country will operate. So the United States Constitution also provides a lot of protections of people's rights. So, for example, the framers of the Constitution were very distrustful of centralized government. And so there are a lot of things in our Constitution of the United States that actually restrict the rights of people. Or I shouldn't say restrict the rights of people. I should say there are lots of things in our Constitution that restrict the rights of government. This idea that if it isn't spelled out in the Constitution, the government, supposedly isn't allowed to do it. So the Constitution is often called the supreme law of the land. And the reason for this is that really no other law can conflict with the Constitution. So that essentially means that Congress can't pass a law that conflicts with the Constitution. The president can't do something that conflicts with the Constitution. Even the city of Bowling Green, or Bowling Green State University for that matter, can't do something that conflicts with the Constitution. So that is why it is called the supreme law of the land. It's essentially the boss law. So it's also extremely difficult to change the Constitution. That's evidenced by the fact that it's really only been changed 26 times through amendments. And, once again, that's 26 times in more than 200 years. And so it doesn't get changed often, and it's actually quite difficult to do so. And so again, Constitution is very important, but one of the things that we'll be talking about a lot in this class is the idea that the Constitution is also, in a lot of cases, open to interpretation. So in a lot of cases, what will happen is if we're wondering if something is unconstitutional, we will essentially call upon a court to decide whether something is constitutional or not. Then we have statutory law. So in reality, statutory law is essentially laws that are passed by legislative bodies. And the chief legislative body that we're talking about here is Congress. So statutory law essentially comes from Congress. Individual laws passed by Congress or another legislative body are often called statutes, hence statutory law. So we talked about, I mentioned that we have the United States Congress. We also have state and local governments might have legislative bodies as well that would pass laws. So statutory law tends to deal with problems that affect a lot of people, whereas we saw court decisions, tend to deal with specific problems. Statutory law is going to be the kind of things that affect a lot of people. So for example, all criminal law is statutory law. So the laws against murder, rape, kidnapping, all of those types of things are statutory law. Once again, just like with the Constitution, after laws are passed, courts are often going to be called upon to interpret them. So for example, if we pass a law that says it is illegal to distribute an obscene newspaper, that's actually very ambiguous. It might sound like it's very straightforward. It is illegal to distribute an obscene newspaper, but when you start to parse that down, you start to see that a lot of that is open to interpretation. So for example, what does it mean to distribute? Obviously, if I, stand on the street corner and sell 10,000 copies of it, that's distribution. but what if I just give one to one of my friends, or one or two to one or two of my friends? Is that distribution? And that's to say nothing of the idea of obscene. What is our actual definition of obscene? So all of these things are basically going to be open to interpretation. And as we mentioned, no law can conflict with the Constitution, and so there have been many cases where Congress has passed a law, and then basically courts have come into play because they have to decide whether this law is constitutional or not. So another interesting thing about statutory law is in most cases statutory law doesn't ever run out. So there are some statutory laws that sort of have a date that they stop being in effect. But generally speaking, statutory law doesn't have an expiration date. And so there's this concept called dumb laws, where there are these laws that are like still on the books that have never actually been repealed and are just sort of ridiculous by today's standards. So just as a couple of examples here, in Michigan, in the state of Michigan, a woman isn't allowed to cut her own hair without her husband's permission. And there is also a 10-cent bounty for each rat's head that is brought into a town office. So these were laws that were passed in Michigan, hundreds of years ago, and are actually still in effect. Now, that doesn't mean they're enforced, but they're basically still out there and technically are still in effect. And then we get to administrative law. And one of the things that happened in the early 20th century, we had the rise of the Industrial Revolution, the robber barons, basically the ultra rich, the Gilded Age, people taking, the rich people taking advantage of the poor people, and that sort of thing. And one of the political movements that came about was the idea of progressivism. And progressivism was based upon this idea that we should use the government as a way to even the power between poor people and rich people. And so this, again, began in the 1920s and continued for several decades, where we basically created a lot of government agencies that were set up to deal with specialized issues. So, for example, there isn't anything in the United States Constitution about television or radio or the internet, and so how do we regulate those kind of things? Well, we have an administrative agency called the Federal Communications Commission to do that. By the same token, there's not anything in the Constitution about flying airplanes and passenger service and that sort of thing. And so we have set up the Federal Aviation Administration, the FAA, to basically make up laws that guide, the airline industries and aviation. So all of these administrative agencies are created and funded by Congress. They are supposed to be independent of Congress, but that's really not the case because, for one thing, all of these agencies depend upon Congress for their budgets. The members of these agencies are supposed to be apolitical, but generally they're not. They are people who basically are appointed to the commissions because they're people who are good in a particular party. And so basically when a president appoints somebody to an administrative agency, it's generally going to be somebody that is from their party and that goes along with their point of view. So, one of the things that if you've gone to Washington, D.C., you might have noticed was when you sort of get outside of the main area of Washington, D.C., where all the monuments are, like a lot of the hugest buildings are these administrative agencies. Once again, the FAA, the FCC, the IRS, these are huge agencies that are again, tasked with regulating a specific area that is very specialized. So one more thing that's sort of interesting about administrative agencies is they have quasi-legislative and quasi-judicial powers. So that sort of means that not only can they make laws, they can actually adjudicate those laws. So in other words, they can make laws and then basically decide conflicts that arise because of those laws. And so that's one thing that makes administrative agencies interesting. I should point out that, even if an administration or an administrative agency actually makes a decision against you, you can further appeal that to a court. But the first step in the process is this idea that the administrative agency actually is going to be sort of the first level of adjudication of any sort of conflict that arises over one of its laws. And then we have treaties. And treaties are increasingly important, for example, in the regulation of world trade. What happens in treaties is governments work out agreements that carry the force of law within the countries that agree to them. And so we have copyright agreements, we've got nuclear proliferation treaties, we've got trade treaties like NAFTA, CAFTA, and the Pacific Partnership, which is basically being talked about right now. And the way that treaties work in the United States is the Constitution gives the president the power to negotiate treaties, and then treaties are basically ratified or approved by a 2/3 vote of the Senate. So the president gets to negotiate them, and then in order for them to go into effect, it needs to be approved by 2/3 of the Senate. And then finally, our seventh source of law is contracts. And contracts are also called private law. The reason for that is because they are essentially laws that are sort of out of the public view in a lot of cases. They might be just agreements between two private parties, for example. And these kinds of agreements might be things like purchase agreements, employment contracts, and if I can just back up to purchase agreement, for example, when you sign up for a cell phone carrier, you're essentially signing a contract. And that contract, in this case, is a purchase agreement where you're basically agreeing to give Verizon this amount of money every month, and you're going to get a phone out of that, and you're going to get service and that sort of thing. And there, as the contracts are actually page after page with all this fine print on them. But again, that's an example of a contract. Also an employment contract. In a lot of cases, when you go to work somewhere, the employer might want you to actually sign a contract. And then also talking about things like transfer of ownership. Like if you have a piece of land or something that you want to sell, essentially that is often accomplished through a contract. So specifically in journalism and public relations, the places where contracts come into play are ownership of intellectual property. So for example, if you come up with a slogan or like a trademark, or you design a logo or something like that, there can be a question over who actually owns it. Did you come up with it while you were working yourself, or did you come up with it while you were basically employed by a company? Because if you came up with it while you were employed by that company, chances are they're going to successfully claim ownership of that intellectual property. Same kind of thing with licensing agreements. You might come up with something and then you might license it to people. So you say that you can use this logo, but you're going to pay me a certain amount of money every year, something like that. And then, as we already talked about, employment contracts. Increasingly it's actually always been the case in broadcasting, where when people would go to news stations, they would usually sign a contract. And it's also kind of creeping into other areas as well. So in a lot of cases, when you go to work somewhere, you might be asked to sign a contract. So talking about contract law, so there are laws that essentially apply to contracts. For example, contract law prohibits any kind of contracts for illegal purposes. So, essentially, if you sign a contract with somebody that they're going to supply you illegal drugs and, you're going to pay them this much for it, I mean, that would be something that would be considered illegal or not a legitimate contract. Also, if a contract unjustly enriches somebody at the expense of another person, that can be the kind of contract that can be deemed to be illegal. And generally speaking, contract law requires the willing participation of all parties. And this essentially means that neither party is being forced into signing a contract. They're basically both doing it voluntarily. And coming back to the second one, both of the parties in the contract sort of have the same general amount of power. So in other words, one person isn't being completely enriched by something that's really gonna, really hurt somebody else. And once again, though, these are all things that, are open to interpretation.